Good morning, this is your Kelso Report for Tuesday, April 17th, and I'm your host, Clark Kelso. We have a full plate of cases today. The Supreme Court granted cert in a copyright action. We have criminal sentencing, health law, death penalty, the Indian Child Welfare Act, attorney's fees, quite a few things to cover today. So let's start with the Supreme Court of the United States, which has granted cert in an intellectual property case involving copyright law. A little over 100 years ago, the Supreme Court adopted the so-called first sale doctrine, pursuant to which the purchaser of a book or other work, once sold by the authority of the copyright owner, has the right to sell the book or other work, even though he or she could not publish a new edition of the work. This doctrine prevents copyright owners from extending the scope of their monopoly rights to prevent a purchaser from reselling on his or her own terms a work that he's purchased. Well, in Kurtzang v. John Wiley & Sons, the issue is whether the first sale doctrine applies to a work manufactured outside the United States. The issue arises because the statutory language of Section 902A of the Copyright Act, which codifies the first sale doctrine, provides that the doctrine applies only to works, quote, lawfully made under this title, close quote. There is a split of authority in the circuit courts about whether this language means that Section 902A applies only to works manufactured in the United States under the Copyright Act, or whether the language should be interpreted more broadly to cover authorized manufacture overseas. It's a very important issue to the publishing industry. The Supreme Court is now poised to resolve this conflict during their next term. Next, we turn to a sentencing case out of the Ninth Circuit. In United States v. Swank, the defendant pled guilty to abuse of sexual contact in violation of Title 18, Section 2244 and 1153. The victim was the defendant's wife's minor niece, who had been staying with the couple while her mother was away. At sentencing, the district court imposed a 2-level guidelines enhancement, finding that the victim was in the custody, care, or supervisory control of the defendant. He was sentenced to 151 months imprisonment. The defendant claimed he was not entrusted with custody, care, or supervisory control, but both the district court and the Ninth Circuit rejected this argument. Factually, the case was not even close. The defendant at all times resided in the home, and he and his wife cared not only for the niece, but also for their own child who lived with them. The defendant shared the caretaking responsibilities, including preparing food for all the children. Given these facts, it was clear the victim was in the custody, care, or supervisory control of the defendant. Next, a health law case. The plaintiff had brought several state causes of action, including a basic product liability claim, in Arizona State Court against Medtronic Incorporated for injuries sustained from the plaintiff's use of a pain pump manufactured by Medtronic. Medtronic timely removed the case to the United States District Court for the District of Arizona, and then the District Court dismissed the claims as preempted by federal law. In Stengel v. Medtronic, a split panel of the Ninth Circuit affirmed the dismissal. According to the majority, the medical device amendments of 1976 to the Food, Drug, and Cosmetic Act, as implemented by the Food and Drug Administration, established federal standards for medical devices such as the pain pump that could not be varied by state law because of an express statutory preemption provision contained in the medical device amendments, and the substantial federal inspection, approval, and regulation of medical devices that occurs under the Food, Drug, and Cosmetic Act. The California Supreme Court had a death penalty decision. After waiving a jury trial, the trial court found defendant guilty of first-degree murder with the special circumstances of robbery and burglary murder, robbery and burglary. It also found defendant personally used a firearm in committing each of the offenses and personally inflicted great bodily injury in committing the robbery and the burglary. After a penalty phase, the trial court returned a verdict of death and imposed that sentence. The Supreme Court unanimously affirmed with a 47-page opinion. The primary issue on appeal was whether the defendant had knowingly waived his right to jury, and the court found the waiver was indeed knowing, intelligent, and voluntary. Next, we have a frivolous appeal. The plaintiff was in default on a home mortgage. The foreclosure proceedings were commenced, and she filed suit to prevent the sale of her home. The trial court initially granted an injunction conditioned on the plaintiff depositing $1,700 a month into a trust account in lieu of an injunction bond. Well, the plaintiff never deposited anything in the trust account, and with the deadline for the foreclosure sale approaching, the bank made a motion to dissolve the injunction, which the trial court granted after holding a hearing, at which the court explained to the plaintiff's counsel that he needed to convince his client to pay or the home would be sold. When the plaintiff failed to pay, within the next 2 days, the court issued an order dissolving the injunction and allowing the sale to go forward. She appealed, claiming that the order dissolving the injunction was invalid because it issued ex parte, a claim which was, of course, factually untrue. But the filing of the appeal had the effect of further postponing the foreclosure sale. Well, after an appellate calendar notice was sent to him, trial and appellate counsel then asked the appeal be dismissed. A clearly irritated second district refused to dismiss the appeal in Brown v. Wells Fargo Bank, affirmed the trial court's order dissolving the injunction, and directed the clerk to send a copy of the opinion to the state bar for its review and consideration regarding possible discipline of trial and appellate counsel. A little lesson there for people trying to block foreclosure sales using civil procedure rules to help. Next, we have a family law case. A father appealed from an order terminating his parental rights as to his son, one A.G. He contended that the Alameda County Social Services Agency failed to investigate his Native American heritage and provide adequate notice to tribes as required by the Indian Child Welfare Act. The agency did not dispute that it violated the Act's inquiry and notice requirements, and instead raised numerous procedural and equitable arguments against reversal. For example, the agency claimed the father had renounced his parental rights. They argued the issue was res judicata. They argued that the failure to comply with the Act was not prejudicial. But in re AG, the first district held that none of the agency's arguments excused its failure to comply with the Indian Child Welfare Act. And the court really had no choice in the circumstances but to reverse the order placing AG pending compliance with the Act. Next, an arbitration case. A corporation had retained a financial advisor to help it obtain long-term financing to enable it to pay off its short-term creditors. But the financing was never obtained, and the corporation then fell into bankruptcy to the detriment of the short-term creditors. Those creditors sued the financial advisor, alleging that his fraudulent misrepresentations induced them to forbear from foreclosing on their security until it was too late. The financial advisor then filed a petition to compel arbitration based on the arbitration clause contained in the advisor's contract with the debtor. Well, in Epitech v. Can, the second district affirmed the trial court's decision denying arbitration, since there was no basis for finding that the short-term creditors were actually third-party beneficiaries of the contract between the advisor and the debtor. Since the short-term creditors were strangers to that contract, they were not bound by the arbitration clause. Creative attempt to use the arbitration clause properly shot down by the Court of Appeal. Finally, we have an attorney's fees case. Attorney Henry M. Lee represented Ms. Chen as her attorney in employment litigation, resulting in a $62,000 judgment in favor of Chong after a jury trial. The trial court also awarded Chong $300,000 in attorney fees under Labor Code sections 1194 and 226. While apparently attempting to avoid paying her counsel, Chong then substituted herself in propria persona for her former attorney. Henry M. Lee countered by moving to intervene in the action and to amend the post-judgment order to make the fee award payable to Henry M. Lee instead of to Chong. The trial court denied the motion, but the 2nd District granted a writ of mandate to reverse the trial court, holding that an attorney fee award under Labor Code sections 1194 and 226 should be made payable to the attorney who provided the legal services rather than the client, unless their fee agreement otherwise provides. That's it for today's Kelso Report. Have a great day in the law.